Welcome to the Employer's Defense Podcast.
Hello and welcome to the Employer Defense Podcast with experienced attorney Clifton Smith. I am your host, Kevin Rosenquist, and today we're going to discuss what goes into defending your business. Clifton, thanks so much for being here.
Thank you. Thanks for having me.
Okay, can you start by explaining what employer defense law is and how it differs from other areas of employment law?
Yes. Let me start by saying that this podcast will be most beneficial for California employers where my practice is located. It may be of general benefit to other employers outside the state, but the ones who will benefit most are those who reside in this state or are located here. So employer defense law is literally a situation where an employer has either been sued, received a lawsuit, or is responding to an investigation or a proceeding before a state or federal agency. And the employer is under a timeline to respond to the lawsuit or the governmental claim or investigation, and it needs defense counsel to enable it to respond. And that's where I come in.
Was there anything specific that drew you to specialize in employer defense law? And what's rewarding about it?
It seemed like a natural extension of my prior activity as a human resources professional. I had nearly a decade in the profession before I became an attorney. And so it just felt comfortable to me. And since I was working for employers for that decade, it seemed just like the natural progression, extension of what I'd been doing previously. And now I'm in a position as an attorney where I can be more helpful to them than I ever could as a human resources professional.
What would you say are the most common types of claims or lawsuits that employers face in today's legal environment?
In this state, right now and for the past 2 decades, what you have seen is a plethora of litigation centered around wage and hour violations, meal period, rest period violations, and also under a law called PAGA, which stands for the Private Attorney General's Act, which enables an employee to actually sue their employer, on behalf of all employees in the capacity of a attorney general, if you will, a deputy attorney general for the state of California in place of the attorney general.
Yeah, I mean, I've heard for sure that California has, definitely stricter laws as far as employer law goes, and it usually favors the employee kind of dramatically. Is that correct?
This state sets the standard for the rest of the nation. And in fact, the federal government will typically look at the laws or a law that California has passed to use that as a framework for a law that the federal government is considering. So yes, it's very forward thinking, shall we say, in terms of employee protections, which makes it a much more difficult landscape to navigate if you're an employer.
I actually know someone in California who had a lawsuit against his company, and it was completely untrue. And when he spoke to a lawyer, it was very difficult to defend. Like, it was very difficult to defend as an employer because of what you just talked about and how it is in California. How have recent changes in legislation or case law impacted the employer defense strategies?
Well, employers have been struggling for 2 decades with existing wage and hour laws, and for the past decade, at least, with PAGA. I think one of the more recent developments that has actually worked to the benefit of employers is the utilization of arbitration agreements that can limit exposure to litigation. It can limit class actions, and it can keep a claim down to a single employee. And in wage and hour litigation, that is definitely a step forward for an employer. It will save you time, it will save you inordinate expense, and it will definitely limit your exposure if you have an arbitration agreement. So that's the one I would probably point to as a more recent development.
Can you walk us through the typical process of defending an employer in an employment-related lawsuit in California?
Yes, typically what occurs, of course, is that I get the initial phone call. The employer has reported that it's been served with a lawsuit. Of course, it's under a 30-day timeline to respond. So that in turn sets in motion a series of activities. If the employer chooses to retain my office, and of course I want to first look at the lawsuit to determine the type of response that's appropriate. At a minimum, you have to answer the lawsuit within 30 days, but you may wish to do something different. You may wish to challenge the lawsuit itself. to point out defects in the lawsuit that may eliminate it. Failing that, you're probably looking at an answer followed by discovery, which is the process by which both sides exchange information. And one of the critical aspects of discovery is depositions. And you want to make sure you get your deposition in first. You want to depose the employee who is suing you. You want to test the theory of the case, see if the employee even knows what the theory of the case is. Oftentimes, I shouldn't say often, but what I have found in my practice is you have plaintiff's counsel who is kind of creating their own theory of the case that may not even be a theory that was ever exposed or espoused by the plaintiff. So you want to pursue that. You want to pursue alternatives to litigation, such as mediation, to see if you can get an early resolution to the dispute. That's something that can save the employer quite a bit of money, cut their losses, and get them out. Failing that, you may want to look at a terminating motion, such as a motion for summary judgment or summary adjudication of the issues, to try and limit or eliminate the employer's exposure entirely before they ever go before a jury. And really, your objective in defense practice is to get these cases resolved before they get in front of a jury, because you never know when you're with a jury, you're rolling the dice, and understand that, quote unquote, a jury of your peers may not be a jury of the employer's peers. The greater likelihood is you're going to have former employees of some sort sitting on that jury, and it may not be a friendly environment, especially depending on what your geography is and where that lawsuit's filed. So I find it's in the employer's best interest to get these cases resolved as quickly as they can and as cost effectively as they can, but with the understanding that there's nothing cost effective about litigation.
Yeah, and I feel like the general consensus in our society is to side with the worker, right? Instead of the employer.
Yes, and I have my own take on that. I've jokingly referred to California as the People's Republic of California because it is decidedly pro-employee. And I've often found that you have opportunists in this state who are disguised as employees that are looking for an extra payday or some extra compensation at the employer's expense. And oftentimes, not often, but I have found on more than one occasion, it's the employer who's actually the victim, where there are theories being propounded that have no bearing with reality and aren't supported by the facts. And so I take an aggressive approach to defense of the employer's interests to make certain that they get their day in court.
Yeah, the example I gave before, the person I know, it was that's exactly what it was. It was frivolous, but yes. I mean, it was frivolous. It was untrue, but it's very, very difficult to defend yourself as an employer.
Yes, frivolous claims come in all shapes and sizes, and thorough research and review of the facts pertaining to the case sometimes unveil fascinating information that was not previously known. You may discover that the person suing your employer has quite a criminal history, which may impact adverse on their ability to tell the truth. And the possibility is that plaintiff's counsel may not even know of it. I had something like that happen very recently, where we discovered that the plaintiff was a convicted felon for mishandling of funds.
Okay, that's not great for credibility.
No, it bears directly on their capacity to tell the truth, and veracity, and it's very relevant.
Yeah, definitely. What are key factors you consider when developing a defense strategy for an employer?
First of all, I want to thoroughly investigate the case itself, and then my strategy typically arises around that investigation. To that, I add my client's willingness to tolerate risk. What is their risk tolerance? How committed are they to defending this case? I have to evaluate the cost factor for that client and have a conversation with them about, potentially what this could cost and what they're willing to invest in the defense of the action. And on more than one occasion, I've had a client that has said, I am not going to have this employee treat me like this. This isn't fair, and I want you to defend me. And so that becomes a paramount concern. So we start there. And then, the theory of the case largely develops around the facts that I'm able to ascertain based on my review of the file, my conversation with the client, and then what I know to be the law of the case. And so I'll take any recent legal developments as one example. You may learn, if you're investigating a wrongful termination case, you may learn that after the employee was fired, they were engaged in misconduct that nobody knew about while employed there, it would have justified their termination anyways. And that factors into defense of the case. So that's one example.
Do you find that it's rare for someone to say, hey, I want to fight this till the end, just because of the fact that you can oftentimes, right, settle for less money than if you push the case all the way to the end? You know, do you find that people are more apt to settle even when they know they're not wrong?
You know, I think it depends on the total value of the case. The greater the cost of the case, the more likely it is that they're invested in defense of the case, even with the cost of defense, because the exposure is higher. Some of these cases in California literally have the capability of putting you out of business. And when a potential employer is faced with that, they tell you, fight it. The best example I can give you of that is class action wage and hour litigation, where every one of your employees has a potential claim against you for, let's say, meal period, rest period violations, PAGA violations. That can add up into the millions. And then there are attorney fees that go on top of that. That is the equivalent of, the nuclear bomb of litigation. It can blow up a business and just cause it to close. They can't cover it.
Is it difficult to balance the interests of the employer with potential ethical considerations in your defense?
No, I've thought about this. We will proceed to aggressively defend an employer consistent with the law. And I have no problem doing that. Even an employer who believes they may have violated certain aspects is still entitled to an aggressive defense, still entitled to legal representation. And oftentimes you can get a good result within the boundaries of the law and boundaries of ethics. That's often the case, especially in this state, because employers can make mistakes all the time just because they're not familiar with the extent of their obligations under the labor code, for example, in this state. So I don't have a problem with that. It's only been on a rare occasion where I've had to say, I can't represent you because the direction you want to go is not consistent with my code of ethics. And usually we get that worked out and resolved at the beginning stages of representation. And in those instances, I don't proceed.
So, we talked about how California heavily favors the worker, which you can understand that to a large degree. But we live in a world where there's a lot of lying, there's a lot of manipulation, there's a lot of people who are looking for a payday and all that. Is California good about saying, like, okay, these are the facts here, let's analyze the facts as a whole, or are they still, even with all the facts in front of them, still leaning towards the employee?
The playing field is decidedly tilted towards the employee. Now, I will say this: if you're in front of a state agency, such as the Division of Labor Standards Enforcement for the Department of Industrial Relations of the state of California, I view that as an agency that is tilted towards representing the employee to recover compensation. And they have a leaning towards that. However, I have found that they have been pretty fair about the presentation of evidence and in defense of the employer. And where the employer is able to provide evidence that the violation has not occurred, they'll come down clearly on the employer's side. They will uphold the law. And so that's why it's important to have your defense pulled together, have your evidence pulled together to make a demonstration of showing that the activities alleged never occurred.
What proactive steps can employers take to minimize their risk of facing lawsuits or claims?
It is critical that you conduct a comprehensive review of your employment practices to make sure they are California compliant. I cannot emphasize how important that is. A human resources professional can achieve that for you. But if you don't have that resource in-house, then I encourage you to find that resource outside of your company as an outside consultant and retain them and have them work through that with you. It will be a fraction of the cost of retaining me for defense of a lawsuit, and it will just save you time and money to make certain that you are compliant with the laws of the state of California. Another step you can take is to make certain you have the processes and procedures in place to ensure that you're California compliant. You should have policies and procedures. You should have a handbook in place, all to demonstrate not just to your employees that you are compliant, but to make certain your supervisors and managers are compliant with California law. And finally, if you can afford it, you want to add a human resources professional to your staff. This person, if they are qualified to do the job that they do, can become a profit center for you as a company. And by that, I mean they will save you money. They'll make you money in the lawsuits you don't have to defend and pay out by helping you avoid those potential pitfalls.
What would you say to a small business owner that might, not have the budget or the need really for an HR person or all that, who might still be concerned that they could get hit with, litigation, like a fraudulent case or something similar?
When you choose to do business in this state, you've already implicitly agreed to incur that cost, to reach out for that resource, to pay for that advice, to avoid a negative outcome. And you have to understand it's not an option for you to blissfully ignore the laws of this state. Understand that your intuition that has perhaps guided you as an entrepreneur to this point, that has made you successful, will lead you astray every time in this state when it comes to employment law. California's employment law is completely counterintuitive. And what you think is appropriate might be just completely wrong and a blatant violation. And until you reach out to the resources you need to confirm or eliminate that concern, you're really not being a good business person. It just makes business sense to go get the resource you need to protect yourself from these kind of claims and lawsuits.
And so if somebody out there listening right now has received a lawsuit or has some sort of litigation or some sort of accusation being made about them, or what would be the first step? What would you tell them? Do this, don't do this. How should they handle it at the outset?
Well, they're under a timeline. They have approximately 30 days to select and retain counsel. So that's one of the immediate steps that has to be undertaken. Another step that has to be undertaken is you have to preserve all the evidence. You can't start eliminating text messages and burning documents and records and erasing this, that, and the other thing. That in itself can be a separate violation of the law. So you want to avoid that at all costs. You want to put a complete hold, a complete freeze on any records or documents related to the lawsuit until it's resolved. You want to meet with your key managers. You want to let them know that there is litigation. Let them know whether or not they're named, because depending on the kind of lawsuit, for example, if we're talking sexual harassment, for example, the plaintiff can name managers or even employees individually. And it may be necessary to meet with those individuals and let them know they've been named as defendants to see if they've been served. They may need separate legal counsel. So there's a number of preparatory steps that need to be taken, but I would say paramount among them is you need counsel immediately, because the attorney you retain will help guide you and direct all of these other activities that must be completed in a timely manner.
That sounds like great advice. Well, thanks for tuning into the Employer Defense Podcast with experienced attorney Clifton Smith. For more information or to connect with Clifton, you can visit cesmithlaborlaw.com. And of course, be sure to hit that like and subscribe button and leave us a review in the comments. Clifton, thanks so much for being here. Really appreciate it.
Thanks so much for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.